Hello everyone, my name is Dr. Ryan Galloway, and I'm going to talk to you about debating the Supreme Court. So my lecture overview is I'm going to talk about the way the Supreme Court works, I'm going to talk about debating courts' affirmatives, and then in my next lecture I'll talk about debating courts on the negative. So the first question is, what is the Supreme Court? And the Supreme Court is the highest court in the land that has ultimate authority over the law in the United States. Now, technically, the Supreme Court just interprets the law, but as we'll see, that's a little bit of a tricky way of saying it because lots of times they do things that functionally are creating new law in the United States. And some people are really happy about that when they get a decision that they like, but other people are unhappy about it when they get a decision from the Supreme Court that they don't like that affects the whole country. And there are 9 justices on the Supreme Court, and they're appointed for life. And you probably are familiar with some justices on the Supreme Court, like John Roberts is the Chief Justice, and Ruth Bader Ginsburg is a very popular Supreme Court justice known as the notorious RBG. And then there are the 2 recent justices that Trump has appointed and have been approved by the Senate, and they are Neil Gorsuch and Brett Kavanaugh. And you may have been following the news on those 2 people when they were nominated to the court. How does a case get to the Supreme Court? Well, it starts off at a lower level. So it could start off as a state case, or it could start off as a federal district court case. And then it gets appealed to the Supreme Court. The side that's not happy, the side that lost at the lower level, says, I think that we're right and we want to go to the Supreme Court. And then if the Supreme Court picks their case, then it goes to the Supreme Court. And like I mentioned a couple seconds ago, they can come from state Supreme Courts or federal district courts. And if you've watched the death penalty lectures, you know about cases like Furman v. Georgia, which obviously was a state Supreme Court case from Georgia, which got appealed to the Supreme Court. Of course, Gregg v. Georgia is the same way. It was a Georgia case that got appealed to the Supreme Court. And then the Supreme Court grants what's called a writ of certiorari to a case, which means they write a document that says that they want to pull the case up, they want to hear the case from the lower level. And it's called the Rule of 4 because it requires 4 Supreme Court justices to decide whether a case will be heard. So at least 4 of the justices have to say, hey, this is a controversy we want to resolve. This is an important case. Let's deal with this case. What does the court do? Well, they meet throughout the year. They're currently meeting on some cases right now. And they only hear about 80 to 100 cases a year. So with all of the cases that are appealed to the Supreme Court, and there are thousands of them, they only hear a handful of those cases. Most cases get their lower court decision affirmed because the Supreme Court never hears the case in the first place. They hear oral arguments on a case, so it's kind of like a debate in front of the Supreme Court. The plaintiff attorney makes their case, and then the respondent makes their case, and they make arguments in front of the Supreme Court. What's different about this in a debate is most of the oral arguments is the justices asking questions to the attorneys. So the attorney will start to make their case, and then they'll get interrupted by the Supreme Court justice, and they will be required to answer the arguments that the Supreme Court justice asked them. They release their decisions usually in May or June, so we're about to hear of a lot more cases from the Supreme Court. And the decision is then binding. The other courts have to listen to the Supreme Court. The executive branch has to listen to the Supreme Court. Even Trump technically has to listen to the Supreme Court, although we'll talk about how those things go down. In other words, the Supreme Court doesn't really have enforcement power. They don't have an army and they don't have money to make sure their decisions get enforced. They only have their legitimacy. They only have the power of reasoning that encourages other people to go along with their decision. But even Trump has gone along with decisions from the Supreme Court before, so there's possibility that even the other branches will listen to the Supreme Court as they usually do. So the next question is, making it specific to debate. Why would you want to read a court's affirmative? And one reason you might want to read a court's affirmative is because it helps versus the politics disad. The politics disad will be very popular this year, especially elections. And because Trump and the Congress don't take the action, you have some angles against the politics disad because those two actors aren't directly involved in the decision-making process. Instead, you get a decision from the 9 justices of the Supreme Court that are then enforced by the other branches, but it doesn't start at their level. It also allows you to claim advantages from Supreme Court doctrine. So if your case dealt with the 8th Amendment, you could say it would spill over to other cases because of the precedent set by the Supreme Court. And arguably, those advantages can't be captured by the executive branch and the legislative branch. It also allows you to claim modeling advantages. So other nations' Supreme Courts look to our Supreme Court to make their decisions. And so you can claim advantages from all across the world because other nations are looking to the Supreme Court for what they'll do. The other reason is you'll probably know more than they do. So a lot of people aren't familiar with debating courts AFs. They're not used to doing it. They're used to debating cases that go through the Congress. And so you'll have an advantage because you know more about what's going on in those situations. So the first reason why you might want to run a court's case is to try and avoid the politics disadvantage. So the question is, do courts link to politics? Well, it's a complicated question. Trump doesn't push the plan, but the court certainly has spillover effects. So things do affect Trump, and given that he's appointed 2 Supreme Court justices, a lot of what the court does will look like it's an effect of something that Trump did. The court also gives the political branches a scapegoat, so they can say we were forced to do this by the other branches, and they can say we didn't want to do it, but the Supreme Court made us do it, which is the reason why we did it. So you can also claim doctrinal advantages. So the court decides cases based on precedent. So what the court's supposed to do is they're supposed to follow their past precedent. They make a decision in one situation and they apply it to another situation. And you can think about it as the way your parents deal with you and your siblings. If they said that you couldn't do something until you were 14 or 15 years old, then you would expect that they would apply that precedent to your siblings, that they can't do something until they're 14 or 15 years old. And at least in theory, that's the way the court's supposed to decide. If they've decided one issue in the past based on a particular decision, they're supposed to apply the reasoning in that decision to a future case. So precedents can spill over to other areas of the law. So probably one of the most famous, if not the most famous case of the Supreme Court is Brown versus Board of Education, which struck down segregation in the United States. Now, Brown versus Board of Education, obviously by its definition, only applied to the education realm. It struck down segregated schools. But the precedent of Brown was used to strike down segregation in other areas of the law, like restaurants, like hotel rooms, like lunch counters, etc., because the precedent established by Brown applied to other areas. So by changing a precedent, you can change other areas of the law. It might only be that your case deals with the death penalty on its face, but it deals with other elements of the law because of the precedent. And arguably, Congress and executive order counterplans can't solve that precedential effect of the Supreme Court. Other nations also model the Supreme Court. In other words, they look to our court as to what they want to do. Because we're the most important court in the world, other nations look to the Supreme Court as to what they should do when they apply cases in their country. And the Supreme Court has unique symbolic effect for other nations. So very popular decisions like Brown v. Board of Education were looked at by other countries and said, hey, the United States is doing this, we need to hop on board and do this too. The US Supreme Court also gets cited by other nations, which means when they're making their decisions, they'll make reference to decisions that the US Supreme Court made in making their decisions. And it gives you international advantages even on a domestic topic. So one of the reasons why debaters don't like domestic topics is they find it difficult to generate a big advantage to outweigh the disads. But if you run a case through the court, you can claim international advantages even though you're running on a domestic topic. The Supreme Court also gives you angles versus lower courts. So I put up the map of the various district courts in the United States and the areas that they affect. And some people will try and run a state court counterplan or a lower court counterplan, but the unique symbolism of the Supreme Court gives you an advantage over those kinds of cases. You also get access to the doctrine of the federal constitution, so states can only interpret their own constitutions, and the Supreme Court has ultimate authority over the federal constitution. So you can get access to the doctrine of the federal constitution. And the debate is fundamentally different than a normal states counterplan debate, and if you are familiar with how those debates work, then you'll have an advantage over your opponents. You'll also have a knowledge advantage. Many people don't know very much about the courts, which is the reason why strategic teams often flock to the courts, is because the other team won't be familiar with how the Supreme Court decides cases. They won't be familiar with the tricks you can use with your affirmative in terms of debating the politics disadvantage. And they might be a politics or economics expert, but they don't know much about the courts. So a lot of debaters, as I'm sure you know, tend to specialize in certain kinds of arguments. And some of them may specialize in the politics disad, which is not a bad strategy on this topic, to know a lot about the politics disad, to know a lot about the elections disad, to have thoroughly researched the elections disad, so you have an advantage over your opponents. But if you're debating a team like that, and they're not very familiar with the courts, then you can gain an advantage over them as they try to link their disad, but you use the various reasons why the court will shield the other branches from the decision, or Trump won't get credit for something that the Supreme Court does, or the Supreme Court is perceived differently by the public than other kinds of actions. With a knowledge advantage, you can also make it sound like you're debating gibberish to your opponent. In other words, you'll know what's going on with the law, but they won't know what's going on with the law. If you have a new balancing test for the Eighth Amendment, for example, if you change the standards in Furman v. Georgia, the other team may not be familiar with what you're doing, and therefore they'll be confused during the debate, and you can explain it to the judge, and they won't have an advantage in explaining it to the judge. So your knowledge is power in the debate. So if you're planning on running a Supreme Court affirmative, you want to get in depth on the reasons why you would run a Supreme Court affirmative in the first place. So in conclusion, Supreme Court affirmatives will be popular on this topic. It's a criminal law topic. The court deals with areas of the law. If you're debating the death penalty, you certainly want to be familiar with the various cases that have come before the court on the death penalty. You can also claim unique advantages. So you might think, because this is a domestic topic, that you can only claim advantages to things that happen in the United States. Not true. You can claim advantages to things that happen on the world stage, and those advantages can help you outweigh the disadvantages. So one thing you really need to think about on this topic is how you're going to deal with the elections or politics disadvantage. It'll be an area a lot of people flock to because big changes in criminal law will influence the political debate. Either they'll make Trump look good, or they'll make Trump look bad, or they make Congress look good, or they make Congress look bad, and you would have the ability to debate that question better than your opponents because how the court affects those institutions is different than how it traditionally occurs with the political capital disadvantages. You can also avoid common disadvantages like the politics disadvantage, and that knowledge will give you an advantage in the debate. The fact that you are more knowledgeable about the Supreme Court and how the Supreme Court functions will give you an advantage. So in the next lecture, I'm going to talk about the negative, but I want you to think for a little while about the advantages that a Supreme Court affirmative will give you.